Hello, my name is Mary Sawicki, and welcome to Prosecutor's Brief. Today, our topic is tips on conducting an effective direct examination in a child abuse case. It all starts with preparation. It's so important that the prosecutor know the facts of the case cold. It's important to prepare ahead of time, knowing what questions you'll be asking the child. Nothing ever runs perfectly in a direct examination, but it's so important that the prosecutor have a sense of the questions that they are going to ask the child on direct examination. It's also important to prepare this child to testify in court. Testifying can be scary for an adult, so you can imagine how fearful a child would be going into a courtroom and having to talk about a sensitive subject in front of people that they know and in front of people that they don't know. Oftentimes prosecutors wonder, how often should I meet with a child to prepare them to testify in court? And the answer is, it depends. Every set of facts are unique. Every child is unique. But usually a prosecutor will meet several times with a child to prepare them to testify in court. Another thing that a prosecutor should keep in mind is filing some innovative pretrial motions in the child abuse case. These particular motions, like a motion for the child to have a courtroom facility dog in the courtroom as they testify, or a motion for a child to bring their favorite teddy bear, a comfort item, to the witness stand as they testify, or a motion to reconfigure the courtroom setup, or a motion that all the parties, defense and prosecution, frame their questions in an age-appropriate grammar and structure. In addition to considering certain pretrial motions to file, the prosecutor should be concerned with what questions they will ask the child as the child takes the witness stand. Number 1, get rid of legal jargon. Lawyers tend to fall back once in a while on such phrases as, "Did you memorialize that? Did you alight from the motor vehicle?" Get rid of legal jargon. Frame your questions in a non-suggestive, non-leading way to the child that are as simple as possible for the child to be able to understand what you are asking them. Avoid pronouns. If on direct examination the prosecutor is using a lot of they, we, you, that can be very confusing for the child. My suggestion is that the prosecutor uses the proper names of the individuals that they're talking about as they frame their direct examination questions to the child. Also, be very careful about asking a child about time. For the prosecutor, a long time ago or a short time ago may mean something very different than what the child thinks a long time ago or a short time ago is. In my opinion, it's more effective to ask the child about an incident that happened, what may have been surrounding circumstances when this incident occurred. For instance, what grade they were in, or what house they were living at, or that type of thing. But to ask a child, did it happen a long time ago, is very confusing. I also suggest on direct examination that the prosecutor use verbatim the words the child uses. In my opinion, it's much more effective. If the child has a special word that they use for their private parts, like pee-pee, then that's what the prosecutor should use in framing the questions. Prosecutors should refrain from so-called cleaning up the language for the court and the jury. Use the words the child uses. Most importantly, I would suggest to the child abuse prosecutor that they frame their questions on direct examination to elicit sensory details from the child. For instance, if this is a situation of sexual assault where the defendant ejaculated on the child, for the child to testify from the witness stand about what the ejaculate looked like, tasted like, felt like, smelled like, can be powerful, powerful testimony. In addition, it's so important to take your time in direct examination of the child. This is not a race. As a prosecutor, don't always be concerned about what your next question will be. Take a breath, ask the question, let the child answer in a pace that they feel comfortable with in their own words. You want to invite a narrative from the child from the witness stand. The prosecutor shouldn't be doing all the talking on direct examination. It is so important to make sure the child understands that the questions that you ask, and silence on direct examination is not your enemy. Let the child take a breath, think about their answer before they answer it. So take your time and do a thorough job on direct examination. Thank you.
Thank you for watching this episode of Prosecutor's Brief. If you have questions or comments, see the contact information listed below. If you'd like further information, please check the links to Calio, the NCAC online library, and other resources listed. As always, thank you for the work you conduct each day in protecting the children in your community.